Welcome to our 1 p.m. session. It's called COVID Coverage and Claims Lessons Learned, presented by Jamie Glanz from Assurance. Welcome, Jamie.
Thank you, Laura. As Laura mentioned, my name is Jamie Glanz. I'm the Senior Vice President of Claims here at Assurance, and I'm only going to admit to 20 years of service. I can tell you what we're experiencing with the impact of COVID-19 on claims is nothing like we've ever experienced before. So what I'd like to cover with you today is the impact of COVID claims on coverage. I want to focus on 4 specific coverages that we're seeing a lot of activity or expect to see a lot of activity around, which is the prop business interruption, workers' compensation, employment practices, and then directors and officers. I want to spend a little time talking about best practices, and then finally I'll cover briefly what we're seeing impacting the legislation and litigation fronts. We expect to see this pandemic have a large impact on the insurance industry, just like all other industries right now. We're seeing furloughed employees, reductions in payrolls and premiums, carriers returning premiums based on audits, and some carriers either independently or through the state orders granting extensions on premium payments. And I think most importantly, we expect to see an overall decrease in premiums with an increase in potential exposures. Carriers are experiencing an influx of claims, especially as it relates to the property losses. It's likened to that of a CAT event, right? Historically, CAT events are limited to geographic regions, and this is making this CAT event or CAT experience more difficult for the carriers, be thoroughly investigating the claims, being present during those investigations, and impacting their ability to send a quality evaluation on coverage. And finally, we're seeing NCCI and other state-specific ratings addressing some of the changes both via classification of COVID work comp claims and keeping this out of the experience mod, as well as allowing payroll of furloughed employees to be considered separately as well. NCCI's website has an FAQ section that they update pretty much once a week, and that resource is invaluable when you're considering what's going on in the classification and rating considerations with NCCI. While this is not an exhaustive list, policies that are providing support in relationship to this emerging exposure I've listed above, in addition to the ones that we'll be talking about today: general liability, professional liability, a lot of event-specific policies, recall, cargo, stock throughput, trade credit, pollution, and then I will spend a little time on cyber. While I won't focus on that today, cybersecurity remains an emerging consideration. We've asked a lot of companies to deploy employees in a quick fashion, and in some cases with little time to ensure security requirements are tested. So with this in mind, making sure that we are using our employees as a line of defense and making sure they report any concerns will help companies know when to utilize the breach resources provided by their carrier. So property coverage is probably, and the business interruption piece is probably the line of coverage receiving the most media coverage right now. There are differing opinions centered on whether this coverage could support businesses through the pandemic. Before I get into the litigation involving, let's review what should be reported. Any client experiencing a business loss or having increased costs as a result of changing operations due to the pandemic or executive orders should be submitting a loss. Companies should anticipate a denial. However, it's important the carrier is given the opportunity to make this determination. Reporting a claim now, your loss is established. You're removing any late reporting or carrier consent issues that could later be raised by the carrier. Clients do not need to have much information to be able to submit a claim. We're recommending these submissions be kept broad. Use the date you began suffering a loss, and most of the times that's going to align with its executive orders or shelter-in-place orders. We typically recommend stating on or around that date, indicating that the exact date remains unknown at the time. Please keep in mind, to report a claim, you don't need to know what the damages are. You need to have your proof of loss prepared or ready to go. We expect the carriers are going to take an adverse position on coverage, so it will be up to the individual insureds to keep track of the losses. Some things we're recommending to support your business income loss would be keep a record of extra expense, keep track of the historical post-loss sales, the historical and post-loss sales, monthly inquiries, historical and post-loss labor records, as well as planned and forecasted sales and production. Be cautious not to provide absolutes. For example, one area we're seeing carriers question insureds on is whether there is property damage. This very issue is being presented to the courts in the litigation pending. Does the presence of coronavirus on a surface meet the definition of property damage? So you want to make sure you're not committing to that and let the courts and the carriers make those decisions. This leads us to taking a quick look at what is required in a standard property policy to trigger business interruption coverage. I don't want to spend a lot of time here because this is going to be very policy specific. However, you will hear talk about covered perils or all risk policies. And essentially what this means is before a business can be covered, it has to be an event at the property which triggers coverage that is not an excluded event. A couple of the exclusions we're seeing the carriers refer to in the policies are the pollution exclusion and a virus exclusion. I point these out again because when you're initially submitting the claim and when you're speaking with your adjuster, you want to be sure to let the carrier make their decisions, and you don't want to confirm for them as this was a pollution event or this was a virus event. You want to let the carrier and eventually the courts decide whether this qualifies for coverage. If and when you receive a denial, it's going to be important to take a look at this. Because of the volume of claims being submitted, we are seeing many form letters with no contact to the insured. A lot of denials are not pertaining to the particular policy in question, but rather a standard policy. All of these circumstances could later assist in challenging the carrier's position, depending on how the courts end up interpreting coverage. I want to take a look at the workers' compensation realm. Again, we are recommending that these claims be reported as well, especially when the employee requests a claim be reported, when there's a positive diagnosis or symptoms from a known exposure at work, and when there's a quarantine from a known exposure at work. And I'll add to this as we start to see some of the states making rebuttable presumptions for first responders and essential workers, that really at this point, any employee who alleges an exposure or a work-related COVID-19 claim, that should be reported. As to how states are responding, we are seeing them really break employees into three categories of workers: first responders and healthcare workers, essential workers, and then really all other workers. Most statutes already designate either first responders or both responders and healthcare workers in their statutes and provide expanded coverage for those individuals. We're seeing states revisit the essential workers and even the general workers in some situations. Some of the thought is that employers are not able to work remotely and are being placed at a greater risk than those permitted to work in a secured or secluded environment. California recently passed a statute where there is a presumption of COVID-19 being work-related, and since then, Wyoming has passed a presumption statute for those contracting this disease through the end of 2020. In addition, Illinois, in response to the emergency amendment, which was challenged and then repealed, just recently came through with what is considered right now a final draft of what they anticipate adopted, which again gives employees a rebuttable presumption, while providing employers some defined rebuttable arguments. Some of these arguments that Illinois is proposing and is in this final draft include if a worker is working remotely, if there are any known exposures outside of work, And this last one, which I think is really important, is whether or not the insured or whether or not the employer complied with the CDC and IDPH guidance, as well as provided protective equipment to the employees. So documenting and understanding this is really going to be critical. I highlighted some of the states, and this guide is already out of date since some of these changes, but this was valid as of 5/7. Whereas likely what will be covered for both those high exposure, which would first responders and healthcare, and then coverage for other high risk, which I think would probably fall into your essential employers. While understanding the importance to provide workers with a recourse, we haven't seen, except in rare circumstances where the work comp has really responded to the common virus in the past. So this is an area that underwriters have not contemplated in their underwriting. And I'll just go on. So this map, which shows the states that currently have legislation enacted related to workers' compensation coverage, as well as those with litigation pending. And you can see there's just a lot of activity going on by the states to try and ensure workers are protected through this. COVID-19 does fall under the occupational disease coverage of the work comp policy if it is deemed to be compensable under the Act. If you have any type of risk retention policy, like a deductible or retro, you'll want to review those provisions, as the retention for the occupational disease is typically per employee, even if the portion of the policy retention is per occurrence. I haven't been talking much about the employer liability exposure, or the 1B portion of the work comp policy, but this is an area I've been concerned about. And since I put this presentation together, I actually became aware of 2 lawsuits filed in relation to employees' exposure to the coronavirus at work. The first was a wrongful death suit filed by a family of a deceased at a Tyson plant in Texas. The family was using the fact that the work comp coverage did not respond or denied compensability, and alleging unsafe work conditions as their basis for the wrongful death litigation. In Illinois, a class action suit was filed against McDonald's by both employees and their families, alleging failure to provide appropriate personal protective equipment, or PPE, and safe work practices. Would expect to see employees' claims barred under, or I would anticipate there'll be some discussion around whether employees' claims will be barred under the exclusive remedy doctrine of the Workers' Compensation Acts. But I do have some concern around the course of action that these families might be entitled to. Being able to document the safety procedures and protocols in place at the time of the exposure, ensuring contract tracing is going on, are going to be 2 critical components that we're going to talk about when we talk about defending these type of allegations. The next round of concerns, or the next wave of activity, I expect we're going to see arise out of employment matters. Anytime there's adversity, the need to make exceptions, and yet there's still a business need, we're going to, these concerns or potential issues are going to arise. I did want to touch on a couple of these issues. So when you are thinking about how you're going to manage your workforce and bring them back into the work safely and fairly, you can be proactive in contemplating the things you need to consider, the safeguards you need to have in place. For ADA, I see issues arising out of people having compromised conditions and needing to work in an exposure-free environment. And I say exposed quotes because I'm not really sure what that looks like at this point. I see FMLA needs, the need to take care of sick family members or needing to quarantine. Discrimination matters, who and when individuals are required to return to work. Are certain groups or individuals being required to return to work at a certain time? This one concerns me in a little bit, in that if you look at most work environments, you tend to see certain departments maybe have one demographic that's more influential or more pleasant or present in that area for certain jobs. And in this case, maybe even certain areas of the facility, and you'll want to make sure you have good documentation to just support your decisions around why one department maybe needed to come back and the other department was able to continue to work remotely. I see the work environment, and I'm actually even seeing this now out in just the social environment, but people are going to be more anxious, and some people more anxious than others. A great example of where this could arise is some people are wearing their masks and others aren't. Some people feel they need to be around individuals wearing masks to feel safe. Others feel like they don't need to wear a mask. So I think managing this is going to help your employees feel safe in the work environment. Whistleblower claims, obviously, I expect we'll see people either maybe reporting to the IDPH or OSHA or other entities that they're not being provided the necessary personal protective equipment, the environment's not being clean or safe. So those employment issues for the whistleblowers could arise from those concerns. And then privacy. In how we manage positive COVID tests and how they are communicated, and contract tracing and being able to let people know when they have exposure, when they need to self-isolate without disclosing who that individual is going to be an emerging risk that we face. And then finally, we have a new dynamic in some situations where people who have always worked in an office surrounding are now being asked to work remotely. Professional is the remote setting. Are there other factors that may, pictures on the wall or other things that other people might find offensive? I think some issues will arise, considerations as well. Employment practices policies are commonly, if not always, written on what's considered a claims-made policy. These policies tend to be more sensitive to when an employer is noticed of circumstances that could give rise to a claim. Once the current policy ends, the new policy asks for disclosures of known circumstance and excludes coverage for those known circumstances. While reporting is still very critical in any policy, under a claims-made policy, the carrier is essentially wanting to be in a position to not have to accept any new claims after the policy expires. In contrast, when you are dealing with an occurrence-based policy like we see on the work comp, the coverage in effect on the date of the event is the coverage that responds. And those carriers do expect to see some claims come in after the policy lapses. So it's very different that you understand the importance and why the claim, from a claims-made perspective, employment practices liability notice is so critical. Carriers will tend to look more closely at circumstances that could give rise to a claim on employment practices liability and have more stringent arguments around coverage and if the potential circumstance develops into a claim during a subsequent policy year. As we look at how employment practices has evolved their coverage over the years, it seems in areas where it's difficult or cost prohibitive to provide coverage, the insurance industry has actions like providing a sub-limit on exposure. We see this a lot for wage and hour claims. Or in some circumstances, they've actually added exclusions, which can be removed in some cases by demonstrating the appropriate risk mitigation policies are in play. And for those of you in Illinois, we're starting to see this around the biometric privacy. So depending on the impact of this pandemic on the employment claims, we may see some type of responses from the carriers. The third or the fourth and probably final coverage we're going to see some momentum around, and I think this is going to be somewhat delayed, is going to be directors and officers liability. Until more recently, directors and officers coverage claims were overlooked or maybe not seen as critical by privately held companies. Well, coverage around these claims is very specific to the business. Some of the areas where the D&O insurance may come into play include a company's failure to disclose or misinformation around the financial impact of the pandemic. Are there investors or dependent parties that your business having an adverse reaction to based on the pandemic and your financial stability following that? Disclosures of preparedness. Are there circumstances where your company's alluded to following specific guidelines and those misrepresentations resulted in reliance by other companies or individuals? The impact of the pandemic on key employees. Are there specific employees whose well-being is an essential or critical part of your company's representations and financial stability? And then company representations. Are you promoting or selling or even soliciting new services in a way that could be misleading, which others are relying on? D&O policies, like employment practice policies, tend to be claims made. So again, reporting of circumstances are a critical component. When looking at the lands of this coverage, we start to see, I suspect we'll start to see things like, possible pandemic exclusions, force majeure or civil authority exclusions, a circumstance where a claim or the circumstances that gave rise to the claim may occur in a previous policy period, but the claim actually develops in the current period, and the current policy period is always the responding policy period for the directors and officers policies when no prior notice is submitted. So keeping in mind that the current policy dictates coverage, and when you're looking at renewals, being aware of any additional endorsements or any manuscript endorsements being presented by the carrier. If there's an adverse effect on your business and you're maybe not able to continue all the coverages or may need to consider some other avenues, look at the tail options of the directors and officers policy. So keeping a tail which will allow you to report claims or the policy expires in place may be a solution or a way to circumvent that problem. So I briefly touched on those 4 areas. I expect to see a lot of momentum, and I want to get around to some reporting best practices. While I discussed this through the presentation, I can't stress the importance of submitting these losses. It's critical to protect your notice when you anticipate a loss. If a circumstance or event falls into an ambiguous area, the carrier may be willing to provide a defense under a reservation of rights. They may be willing to participate in some fashion or even all of the loss. But if you don't submit a claim, the carrier will have no obligation. Even if later there's a change in the interpretation of a policy provision. Trust your judgment. If something feels like it's headed to a claim or a situation that develops that might give rise to a claim, those are worth reporting. I like to always say trust spidey senses. When an individual brings you a concern or a situation that might give rise to a claim, and more than ever right now, we need to make sure those are being submitted to the carrier and we're giving them notice. I'm not going to spend a lot of time speaking to best practices around claim reporting. I think we've covered that a bit, but I do want to talk about submission, and there are some key elements of the submission that you want to make sure you're speaking to, and that's being broad, being non-specific on the date of loss, giving yourself some wiggle room as to when it occurred, and watch out for any definitive. So be careful not to, if a question asks, is this a virus? Is this, was there property damage? Be careful not to answer that in a yes or no fashion. Be careful to be, I always say, be a little, ask the question itself. Well, I don't know, has anybody classified this as a pollution, or has anybody classified this as property damage? As far as you know, you were forced to close your business due to a state order, and you're still investigating the details around that and what the damages look like. When we switch over to talking about your investigation, you need to think about a couple things. One is the scope. Start out on a small scale. Look at where your business, your neighboring businesses, the employees that work for you, Then look at a larger scale, which is the county and state. Target specific events. Keep good documentation on what you're doing for safeguards, costs related to those events, document any known exposures. Stay connected with your staff. Your staff is going to have information on personal events that may play into a claim, known exposures of other employees, maybe neighboring companies, travel. Keep thorough records. The carrier is not going to be asking for a lot of information up front, as we talked about before, since we expect most of these cases to be, or claims to be denied. But they are going to need that at some point if we do determine that there is coverage around some of these policies. Be broad in your claim submission and the coverages you submit. So if you have a situation, look at all the coverages you have in place and see what may provide coverage and go ahead and place them on notice. The worst that can happen is they can send a rescission or try and file a motion with the courts to get the claim dismissed. And if you agree with that decision, you can allow that motion to move forward. So there's really no harm in submitting it and having a broad submission to the carriers. I'll spend a little time talking about the legislation and litigation landscape. We could probably spend the entire day speaking to what's going on both on a state and federal levels and the changes that have happened from March through April and even until now. However, there are some areas to be familiar with or that you're going to focus on. Some of those areas include: when did the emergency or shelter order go into effect? What was the reopening provisions that were outlined? If you, like I know in some states, there's some discretion being given to how companies reopen, utilizing CDC and other guidelines on how you safely reopen and when it's safe to reopen. What immunity order the government enacted, and what categories of employees do these immunity orders provide protection for? So if you have essential workers or healthcare workers, does the immunity expand? When you open up, it's going to be very critical if the immunity does not expand to them that you have your defenses and you understand how you could potentially defend that litigation. Well, not seen much success in the order of legislation. I do know New Jersey was attempting to pass litigation to speak to coverage for business interruption and really try and dictate that these business losses or the endemic loss is covered under the property policy. And while I'm not sure that that's going to gain traction now that we have so much litigation going, it is something just to aware of. We're seeing a lot of suits by insureds challenging the carrier's denials on business interruption across all venues. And there's a request to have a class action accepted under a multi-district litigation, which could mean we have one ruling that would cover multiple venues and similar policies. I mentioned that employee claims being presented in the civil courts, and I expect to see other liability claims starting to develop around negligence resulting in COVID-19 exposures and diagnosis. As claims do, they tend to be a lagging indicator of our exposures, so be thoughtful with your actions. Be sure to work with your carriers and brokers on possible coverages being impacted. And with that, I wanted to leave both my contact information as well as Kelly Cyprin at Assurance, her contact information as well. Both of us will be available to help guide or answer any other questions that you may have. I thank everyone for their time today.
Thank you so much, Jamie, and we appreciate your time today. I invite everybody to come back at 2 o'clock for Find Sales Now and 9 staffing sales ideas presented by David Cerns. Thanks again, Jamie.
Thank you.